Good morning. Welcome to the Bay Area Experience, evidence-based policy webinar series organized by Policy Research at Hong Kong IAPS and co-sponsored by the CUHK Global China Research Program. I'm Fanny Cheung, the convener of Policy Research at Hong Kong IAPS and the moderator of this webinar series. CUHK Policy Research at Hong Kong IAPS program is dedicated to promoting cross-boundary and interdisciplinary collaboration on policy research. To facilitate academic exchanges and social awareness of different policy issues, we invite scholars, policymakers, and stakeholders to discuss policies across different areas. The focus of this series is the strategic development of the Guangdong, Hong Kong, Macau Greater Bay Area, or GBA in short, one of the strategic focus areas of our Global China Research Program. As you probably are all familiar with, the GBA comprises of the two special administrative regions of Hong Kong and Macau, and the 9 municipalities of Guangzhou, Shenzhen, Zhuhai, Foshan, Huizhou, Dongguan, Zhongshan, Jiangmen, and Chao in Guangdong Province. The development of the Greater Bay Area is key to the strategic planning of the country. The aim is to leverage the advantages of the above cities to contribute to the cooperation and integration among districts and to promote regional economic development. The plans for the Greater Bay Area cover multiple policy areas, including innovation and technology, economy, urban planning, education, law, and others. We have planned a monthly Greater Bay Area webinar through August 2022. Today's webinar is on the economic integration and the law in the GBA, how the Qianhai court handled Hong Kong and Macau-related cases. The effective resolution of civil disputes is widely regarded as part of the critical infrastructure required for sustainable economic growth. It is therefore important to form an empirical understanding of how disputes in the Greater Bay Area are resolved. Drawing upon a dataset of all publicly accessible court judgments handed down by the Qianhai court in Shenzhen during the 2015 to 2020 period. This talk reports the preliminary findings of an empirical project that looks into the court's handling of Hong Kong and Macau-related cases. Also to be discussed are the implications of these findings for cross-border dispute resolution in the Greater Bay Area. Our speaker today is Professor Chao, Professor, Faculty of Law at CUHK. Our two discussants are Professor Dicky, Associate Professor at the Faculty of Law at CUHK, and Dr. Xiaoyan, Honorary Research Fellow at Hong Kong Institute of Asia-Pacific Studies at CUHK. Let me first introduce our speaker. Professor Chao is a professor and the Associate Dean of Research of the CUHK Faculty of Law. He also heads the Chinese Law Program of the Hong Kong IAPS at CUHK. His areas of expertise include company law, securities regulation, financial law, and empirical legal studies. He has published extensively in leading peer-reviewed international journals such as the Banking and Finance Law Review, European Business Organization Law Review, and Journal of Business Law. His research also has received significant funding support from the Hong Kong SAR Government Research Grants Council, the PRC Ministry of Education, the Government of India, and the Sumitomo Foundation. Please join me in welcoming Professor Chao. Professor C, over to you, please.
Thank you, Fanny, for your very kind introduction. It's a great honor to have been invited to be part of this very worthy and a very important initiative. I feel deeply honored. And before I start, I would also like to thank my colleagues, Professor Dicky Tsang and Dr. Xiaoyan Ho, for very kindly agreeing to be the discussants today. Now, I will very briefly first of all, give an introduction of the general background of this project. I will say a few words on the methodological considerations, especially the data collection, the evidence collection process. Then I will delve into some of the details of the findings, and I will try to conclude with some preliminary recommendations on a policy level. Now, the very broad backdrop of this research is the Greater Bay Area, or the GBA. Now, this is, to be very brief, this is a national strategy, and it has been very high on China's national policy agenda. Now, I think to this audience, I don't need to give the details, but only to say there are a number of very important framework arrangements. Now, this includes, obviously, the 2017 framework agreement between NDRC, the National Development and Research Council, Guangdong Provincial Province, Hong Kong SAR, and Macau SAR, which really set in motion the GBA project. Now, more recently, in 2019, there has been a outline development plan, which has been implemented in the last couple of years. Now, that is also a very important policy document jointly enacted by the CPC Central Committee and the State Council, which is the central government of the country. Now, with that in the background, as a lawyer, there's a legal perspective to this very important policy development, and that has a lot to do with the role of law, or more specifically, with the role of an effective and a functioning legal system. Now, it is perhaps universally recognized that law does play some role in sustainable economic development. Now, there has been an official recognition on the part of the PRC central authorities that while the rule of law is itself central to the business environment, or using the general slogan, 法治就是最好的营商环境. While rule of law is the best business environment that one can be given. Now, as a broad translation. Now, and this is something which is perhaps broadly and internationally recognized by, well, the new, for example, the new institutionalism, which places emphasis on the role of institutions, in particular, contract law and property law, or to be more precise, the legal protection, especially judicial protection for contractual rights and property rights, and the role that those institutions can play in facilitating economic growth globally. Now, so the general premise for this research is that law matters, and effective and a functioning legal system, in particular judicial system, which provides efficient dispute resolution mechanisms, is something which would be central, something which would be very important, critical, if you like, to the future growth, to a sustainable growth of the Greater Bay Area. Now, let me just very quickly to draw your attention to a number of institutional development which bears directly on the legal environment in the GBA. Now, at national level, there has been a number of very important initiatives and arrangements between the mainland, the Chinese mainland, and the Hong Kong SAR. Now, and all these initiatives, as you can see on the slide, has been made possible under Article 95 of the Basic Law. Now, central to all these arrangements is the reciprocal recognition enforcement of judgments, especially in the civil and the commercial law fields. Now, let me just highlight three of them without reading out their full title. Now, back in 2017, there's this arrangement for reciprocal recognition enforcement in the area of matrimonial and family cases between the mainland and Hong Kong. And in 2019, this was further extended to the more general field of civil and commercial matters. And just last year, this was further extended to a very important field of law, which is essentially the bankruptcy law, insolvency, if you like. Now, and there have been also other important arrangements at the GBA level. Now, just to name one of them, back in 2019, there was a general framework agreement between Guangdong Provincial Higher People's Court and the Hong Kong SAR DOJ on enhancement on exchange and mutual learning between the two very important components of the GBA. Now, with that as a general background, let me just get to the key character, the main character of this exploratory study. Now, it is the Qianhai Court. Now, its full name is the People's Court of Qianhai Corporation Zhong Shenzhen, or just generally known as Qianhai Court. Now, compared to its mainland Chinese counterparts, most of them, this court, Qianhai Court, is a relatively newcomer. Now, it was established back in January 2015. But this is a very special in many different senses. Now, part of it, which is central to today's presentation, is that it is the only Shenzhen-based recognized primary people's court under the Hong Kong mainland judgments reciprocal enforcement ordinance. So essentially, Qianhai Court is the sole court in the whole of Shenzhen, which handles which has been recognized as a court whose judgment will be enforced and recognized generally under the ordinance. And that has a lot to do with a rather unique arrangement, which is generally known as concentrated jurisdiction or 集中管辖 in Shenzhen, meaning that in Shenzhen municipality, all cases which are Hong Kong, Macau, Taiwan, or otherwise foreign related, these civil and commercial cases, they're all concentrated in the hands of Qianhai Court. So this is a rather unique arrangement, which really places Qianhai Court at the center of the stage. Now, Qianhai Court in recent years, since its inception, has really carried out a good number of very interesting pilot schemes. Now, I can't give you every detail, but its initiatives on ADR, alternative dispute resolution, such as mediation, arbitration, so on and so forth, has generally won a lot of recognitions in the legal profession, as I was given to understand. Now, Qianhai Court has also taken the initiative to appoint the so-called expert people's assessors, essentially legal experts primarily, from Hong Kong. Now, I must make a declaration here, which is that I'm one of those appointed Hong Kong expert people's assessors, which I believe gives me some insights into how the Qianhai court has operated. Now, there's another very important feature of Qianhai court, which makes a study of its court cases particularly interesting. And that is, it appears to be, since its foundation, it appears to be a national leader in the handling of the so-called Hong Kong, Macau, Taiwan, or foreign civil and commercial cases. Now, it has been a bit challenging to get all the necessary official statistics, but our broader sense is that while Qianhai has actually handled a good proportion of these HAMTF civil and commercial cases. Well, depending how you look at it, broadly, Qianhai, I think in the past couple of years, has handled about 1/6 of all these, Hong Kong, Macau, Taiwan, and the foreign-related civil and commercial cases in Guangdong province. And arguably, it has handled about just over 10% of national cases, while all cases across the country in this particular field. So that makes Qianhai a particularly worthy court to look at. Now, let me just give you some details on how this research has been conducted. Now, basically, what we have done, the team, is to try and extract, trying to do data mining on official source of mainland Chinese courts judgments, and it's called China Judgments Online, 中国裁判文书网. Now, this is one of the Supreme People's Court, which is the highest level court in the PRC. It's one of its judicial transparency initiatives. Now, broadly speaking, all courts in the PRC, they have been instructed by the Supreme People's Court to upload as much as possible, well, subject to some exceptions, their judgments, the full text, in general, their judgments. Now, so what we have done is to go into this China Judgments Online and try to data mine as many cases as possible, those cases which have been handed down by the Qianhai court. Now, the sample period, the period of investigation, started from the 28th of January 2015. Now, it is because that is the first date on which Qianhai court has ever handed down a judgment, a Hong Kong or Macau-related judgment, which has been made publicly accessible on the China Judgments Online. Now, the sample period ended on the 11th of August 2020. Now, that is essentially the cutoff date. That is the date when we started our data collection process. So there's no particular reason as to why it is that date. It's just on that day we started our data collection. Now, we have collected a large pool of judgments handed down by the Qianhai court. And then we have done we believe, a thorough data cleaning process. So what we have done is to look into every single judgments handed down, the sample judgments handed down by Qianhai court to determine whether they are all really Hong Kong or Macau related. Some of the judgments are simply sometimes are not really Hong Kong or Macau related, as we later found out. Now, eventually, we ended up of having close to 1,800 Hong Kong or Macau related cases, among which we have about 1,763 Hong Kong cases, related cases, 27 Macau related cases, and 4 of which were related to both Hong Kong and Macau. Now, before we proceed to give you our empirical findings, let me just highlight one very important methodological consideration. Now, and that is, we do not claim that this sample, even though it is, I think it is what is publicly available, we do not claim this sample is or was representative of Qianhai court's judgments, because it has been well documented. There is, let's say, a selective uploading practice by PRC courts, meaning that PRC courts, we suppose, including the Qianhai court, they have selectively uploaded the civil and commercial cases, and it has also been documented, well documented in the literature, that we, as academics, as outside observers, we do not yet fully understand as to the criteria, the standard by which the cases have been uploaded. So therefore, there's a potential methodological issue, which is the so-called non-random missing data. So we would expect that some data would be missing, and they are missing on a non-random basis, which means while we get to be very careful as to how much generalization we could do with our sample. Now, it is with this caveat that let me just explain a bit more about data collection process. Now we have, as I've explained, we have hand-collected data. The team, including myself and two other key members, we have looked into every single cases. We record the case name, case number, course of action, trial date, foreign related matters, so on and so forth. And we have basically done a coding of those cases. Now, all this was possible at all by a very generous support from a very important research initiative from the CUHK, which is CUHK Research Committee, Research Sustainability of Major RGC funding schemes. Now, some of the preliminary findings have been published in Hong Kong and Macau Studies, one of the leading PRC journals in the field. So if you're interested, I'll be happy to send you a copy of the publication. Now, I should emphasize the research is exploratory in nature. Now, let me just take you to some of our preliminary findings. Now, the first line of finding has to do with the so-called accepted cases and concluded cases. Now, let me just try to explain what we mean by these two terms. Now, accepted cases, essentially, these are the cases which have been accepted, which have been successfully filed with Qianhai Court. And then concluded cases essentially means, the group of cases which have been handled and a judgment has been handed down by Qianhai Court. So generally, we see a pattern of trending up from 2015 all the way to 2018. Now, there appears to be a bit of a drop in 2019, and there appears to be a sharp drop in 2020. Now, we suppose that would have a lot to do with the uploading process, which can take time. So we don't think that is a slowdown, if you like, a real job in the caseload. Now, secondly, we look at the case types. Now, by case types, we essentially we have relied on this Supreme People's Court interpretations on all sorts of or civil courses of action. Now, what we found out is that while Qianhai Court appears to have handled a very wide spectrum of civil and commercial cases, as many as 36 types, according to this Supreme People's Court judicial interpretation. Now, all the way ranging from contract disputes to family disputes, and from contract law disputes to intellectual property disputes. Now, there are two types of cases which really have taken up the lion share. Now, the largest cohort is the contract-related dispute. So we have on the slide, we have a very broad breakdown of the two types. Now, the second runner-up is the group is company-related disputes. Now, among the contract disputes, you have basically private lending cases, civil cases, contract law cases in which private individuals and private entities, including private companies, they make private lending among themselves. Now, arguably, this might be reflective of the nature of the GBA businesses and commercial transactions. Now, the third aspect of our empirical findings is really the so-called foreigners. In other words, in what sense, from the legal point of view, a case is or was categorized as foreign. In this particular context, Hong Kong and all Macau related from the private international law point of view. Now, so here foreign doesn't really mean a foreign country or foreign jurisdiction, but basically it refers to a jurisdiction which is, not the PRC, especially the mainland of the PRC. So in that sense, Hong Kong and Macau would be categorized as a non-PRC mainland jurisdiction. Now, there are three possible ways by which a case would be categorized as a foreign case or foreign-related case. One, the subjects or the parties, the litigants, if you like, one of them is foreign. In this case, Hong Kong or Macau based, either Hong Kong or Macau resident or an institution, entity or corporation typically that is incorporated, that is established in Hong Kong or in Macau. Now, that amounted to about 96% of foreigners. Now, then you have about 2% which had to do with the so-called foreign objects, meaning, the matter that is categorized as foreign under private international law has a lot to do with a property, for example, in Hong Kong. So, or Macau, so for example, shares in Hong Kong incorporated companies will be categorized as foreign objects. Now, there's another important category, which is foreign relationships, which essentially means, the legal relations in the case, either arose or somehow implemented, performed, or sometimes terminated in Hong Kong or in Macau. Now, again, that is just a very small share. Now, another perspective of our empirical finding is the so-called jurisdiction. Basically, it means, which court has the jurisdiction over a dispute. Now, under PRC law, there are a number of legal bases for determining the jurisdictions. Now, it could be jurisdiction could be determined by agreement, which means the parties to a contract, for example, may decide among themselves or between themselves which jurisdiction has the say. Now, it could also be legal jurisdiction, which means, under PRC law, the law would somehow point to a jurisdiction which can hear a case. Now, in most cases, 98% it is legal jurisdiction. So it's just by operation of law. Now, there's another 2% which is jurisdiction by way of parties' agreement. Now, there's yet another very interesting angle to our finding, which is parallel litigation, meaning while on the basis of same set of facts, two or more than two lawsuits, litigation, if you like, are brought before a Hong Kong court and at the same time before a PRC court, a Chinese court. Now we identify 5 of them. Now that obviously had to do with a very important legal question, a legal principle, which is judicial comity. Now, yet another very important perspective of our empirical findings is the so-called determining of the applicable law. Now, meaning the law which should be used to govern the case. Now, we've looked into these our sample cases. Now, in a good majority of our cases, which is 61%, the court basically used the closest and the most through connection principle, which means the court will decide which legal system, be it a Hong Kong legal system or be it the mainland PRC legal system, has the closest connection to a case. So that is a majority. Now, we do have about close to 20% of cases where the governing law or the applicable law was essentially decided by the parties themselves. So that is 20%. Now, we do have another 13% where there's no discussion, there's no indication in the court case, the judgment as to how the governing law or the applicable law excuse me, was determined. Now we then zoom in to take a closer look at exactly how those party autonomy cases, if you like, how they were made up. Now, essentially, you have about 80% of those cases where you have essentially a contract clause which provided for the governing law. Now, then you have about 20%, just over 20%, where the parties essentially reached agreement on the applicable question during the court trial. Now, we look at those cases and try and find out what was the applicable law, what was the governing law, which was determined, which was chosen by the parties. Now, we found 48 cases where the parties actually chose Hong Kong law or Macau law as the governing. Then we have 204 cases where you had a contractual provision on the applicable law being very ambiguous. Now, a very important finding, I believe, which really echoes some earlier studies, some very important earlier studies, is what is known as a homeward trend. Now, that basically means, and I believe Professor Tsang will say more on this later, that basically means, a court shows a tendency, a trend of applying the law of its own, of the whole country. Now, in this case, we identified that as much as more than 98% of the cases handled by the Qianhai court actually applied the PRC law. Now, essentially, the law of the home jurisdiction. Now, that's pretty much supported early studies, including 2 very important studies of one of our discussants, Professor Tsang. He has published 2 very, very important studies on this in 2020 and in this year as well. Now, I think we are running out of time, but let me try and give a quick wrap up on potential policy implications of this study. Now, the first policy implication is that there appears to be a scope for Chinese courts, the PRC courts, to develop a greater awareness of private international law. Now, apparently, the homeward trend in our sample cases appears to be very significant. And another colleague of ours, Professor Lutz Christian Wolf, has also done a study, and he has suggested some track on homeward trend should be placed, and PRC court should really guard against the so-called flexible choice of law rules. Secondly, there appears to be a scope, a need actually for greater cooperation, be it judiciary-centered or profession-centered, on determining Hong Kong and Macau law in Chinese judicial proceedings. I think some very important initiatives are ongoing now. Now, there might be some need for greater mutual judicial committee, but apparently that should be subject to national security and the public order. Now, there has been some discussions as to the need for model contract clauses or model court cases that might be warranted. The discussion might be warranted. Now, finally, there appears to be a scope for the use of legal tech to bridge information gap, and I believe our project might have presented a very modest step towards that direction. With that, I conclude my presentation. Over to you, back to you, Fanny.
Okay, thank you very much, Professor C, for this very informative study. Let me first introduce our first discussant, Professor Dicky Tsang. Professor Tsang is an associate professor at CUHK Faculty of Law. He chairs the CCTL Private International Law Group at CUHK Law, and his main research areas are private international law and company law. His work has appeared in a number of leading international journals, including the Virginia Journal of International Law, the Vanderbilt Journal of Transnational Law, and multiple articles in the Journal of Private International Law. Prior to joining academia, he practiced as a corporate finance lawyer at two leading international law firms, working in the New York, London, Hong Kong, Beijing, and Shanghai offices. He is admitted to practice in the state of New York, England and Wales, and Hong Kong. Please join me in welcoming Professor Dicky Tsang. Dicky, over to you, please.
Thank you very much, Professor Chang, for the very kind introduction. I'm going to do three things because I think I only have 10 minutes. The first thing is to congratulate my dear friend and colleague, Professor C, for his excellent research. And I'm going to tell you more about that research. The second thing, of course, is to comment on the substantive findings of the research, which I will do very soon. And lastly is to ask some questions. Like all great researchers, they inspire questions, and I will ask those questions towards the end. So in terms of substantive comments I have, so I'm going to comment on the empirical research structure. I think that's excellent, and I will tell you why. And then I will comment on the two areas which Professor C introduced to you regarding his empirical research, jurisdiction, and choice of law. Now, finally, we said private international, we asked three questions, generally, jurisdiction, choice of law, enforcement. While enforcement is not part of Professor C's research, how enforcement will impact on his area of research, jurisdiction, and choice of law, this is what I'm going to comment in the end. First of all, I want to talk about the empirical research structure. I think I want everyone in attendance to know the importance of Professor C's research. To my knowledge, it is the only empirical research on the private international practice of Qianhai courts. Now, of course, the Qianhai courts of significance had been introduced by Professor C, which I would not spend more time on. In short, Professor C has cornered this very important empirical research. That's the first thing I want to say. And also, although this is not the first empirical research on private international law, I would like to highlight that in China, at least as far as I know, there's no empirical research on both jurisdiction and choice of law. Now, most of these empirical researches focus on only jurisdiction or only choice of law. And I think for professors to cover these two areas together in one piece of research, I think that's very impressive. The third impressive thing about this empirical research is the large sample size. Now, Professor C just focused on Qianhai courts, and the sample size, 1,790 between this 6 years period, that is a very large sample size comparing with similar type of research, particularly if we only look at just Qianhai court. And Professor Stephensy exhausted all the publicly available cases. And I am certainly interested in private international, and I have conducted empirical research on choice of law in China. Now, my research, my survey period is shorter, only between 2015 and 2018. I found 430 cases decided by Qianhai court. So it just contrasts to you how thorough and how complete a research Professor C has done. And I think this is another, the next thing is how the data has been collected, hand collection. Professor C utilized Hong Kong, Macau, and Qianhai court as the search terms. Now, for those of you who haven't done this type of research, you may not appreciate how hard to use these broad research terms. Professor C could have just used certain statutory provisions for the search, but if he had taken that path, you will have missed those foreign-related cases that did not go through a choice of law process. I think very important to highlight that Professor C managed to find those cases where the court should have, but did not manage to go through this choice of law process. But to find these missing cases, you will have spent much longer time in front of the computer to identify those cases. So these are very impressive traits I find about Professor C's empirical research methodology. On to the substantive finding, jurisdiction. Now, I only focus on one thing, which is parallel proceedings, which Professor C mentioned earlier. To me, this does not appear to be a big problem because in Professor C's research, he only found 5 such cases out of close to 1,800. Now, it's not ideal parallel proceedings, but based on the data I look at just and Professor C mentioning just now, 5 is not a very bad number. Now, how to reduce parallel proceedings? Parallel proceedings create a problem which we call in private international jurisdictional conflict. And for this, we say there are 3 major ways to resolve problems: form nonconvenience, original common law principle where the court can decide to decline jurisdiction to stay the proceedings, so to speak. Now, form nonconvenience exists under both mainland and Hong Kong laws. Now, I don't know to what extent these 1,800 cases have examined these aspect form nonconvenience, but I'm saying that the result being 5, just 5 parallel proceedings, maybe because both courts, Hong Kong and mainland courts, apply form nonconvenience. Now, another way to reduce jurisdictional conflict is anti-suit injunction. Now, this is the opposite form nonconvenience. Instead of saying that we decline to exercise the jurisdiction we have, we say we prohibit the party to go to another court with parallel jurisdiction to litigate there. So this very intrusive, very offensive type of procedural remedies available to a court. Now, fortunately, although mainland over the last couple of years designed its own anti-suit injunction regime, to my knowledge, it had never been exercised beyond certain courts in China. Certainly not the Qianhai court. So I think it's a very good thing that we don't have anti-suit injunction between Hong Kong and mainland, at least between Qianhai court and Hong Kong. And finally, another way to resolve jurisdiction conflict is to enter some sort of arrangements, which Professor C introduced, and I will talk about this more in the enforcement section. Now, further questions here. So what I want to see more, what can be done more? To ask question, so how many of these cases are derived from exorbitant jurisdiction? Now, Chinese court have been criticized for having too broad a jurisdictional basis. So, for example, court can have jurisdiction when the defendant has distrainable assets, which may or may not have anything to do with the litigation. Now, Professor C's research, I did not see the discussion there, but it's not a problem per se for the research itself, but this is something I think scholars should look more into in the future. Now, because of time, I go to choice of law now. Another issue that highlighted by Professor C was the homeward trend. Now, the number is 98.6% of the cases applying mainland law. Now, this may look as a huge problem, but going back to the person, Nussbaum, who created this term in 1932, he actually himself did not think it was a problem per se. Why? Because a court is always the best at applying its own law. PRC courts are best at applying PRC law, not other jurisdictions' law. So I don't see the number itself being a problem. The question is why, right? The way I see it, because most of these cases are contract cases, parties are given opportunities to choose foreign law by a choice of law clause. They chose not to insert it. So I think this is not a huge problem per se. Further question. I think we should focus on how and to what extent foreign law can be proved. Because parties can choose choice of law through express choice of law clause. But the important question is, well, does Qianhai court respect the choice by the party? Now that's the question. And these are further areas that deserve more research. And final thing I want to say is the enforcement. Now, we know that there is a new enforcement arrangement to be implemented into law in Hong Kong, hopefully later this year. And under this law, particularly Article 22, it will further minimize jurisdiction conflicts. Why? Article 22 of the arrangement says if in the course of adjudicating a civil and commercial case, let's say Hong Kong, a party bring in a Chinese judgment, the Hong Kong court will have to stay the proceeding. Now, in this sense, jurisdictional conflicts will be further minimized, not to say eliminated. All right, so conclusion, I think the article is a great contribution to both private, international, and Greater Bay Area. And I think we have seen very positive developments in the cooperation and harmonization of private international between mainland and Hong Kong. And I would invite Professor C to further research on enforcement and expect what not covered by this research, but I think worthwhile to consider. Thank you very much for your time.
Thank you, Dicky, for your very clear discussion. Our next discussant is Dr. Xiaoyan, Honorary Research Fellow at the Hong Kong Institute of Asia Pacific Studies. Dr. Ho is a leading legal data specialist. She received her legal education from Peking University and Temple University. As the former senior prosecutor in Beijing, she won multiple prestigious awards and titles. She worked for prosecution services at the grassroots level and intermediate level in Beijing for over 20 years and has offered consistent observations and insights on China's legal reforms and judicial practices. She has published academic papers on issues related to prosecutory discretion, legal big data and technology, evidence law, the right to counsel, and other matters. Please join me in welcoming Dr. Ho. Dr. Ho, please.
Okay. Thank you. Thank Professor Zhang's a very kind introduction about my education and working experience. And I'm very glad to join today's discussion. Just now, Professor Xi's presentation and Professor Dicky Chang's comments, I think are all very insightful and excellent. They present a complete and in-depth analysis of the judicial practice of relevant cases handled by Qianhai Court. As we know, unlike other Bay areas in the world, the GBA involves 3 jurisdictions. So how to resolve these cross-border disputes is definitely worth exploring. As for the past 5 years, I worked in a legal data company and also did some researches relating to data. Professor Xi's research actually are thoughtful in many aspects. And based on my own working experience, I am particularly interested in the research methodology. This research takes an empirical way to study the judicial practice of GBA, observing the data set of public court judgments. And I think in a broad sense, this belongs to data analysis and involves interdisciplinary study. Court judgment is a kind of text data. It contains natural language and legal concepts. This makes it more difficult to extract information useful for our research. For instance, how to define Hong Kong and Macau-related cases in legal sense? Does it mean at least one of the parties is from Hong Kong or Macau, or the case facts are related to Hong Kong or Macau? This is the task for legal experts. According to a white paper issued by the Qianhai Court in May 2022, they summarized the characteristics of foreign jurisdiction-related cases. When the party, contract object, case facts, and other elements of a case are related to a jurisdiction other than mainland China, then such case is characterized as a foreign jurisdiction-related case. So when we make this definition clear, we need to face the data set, locating the corresponding keywords or sentences in the court judgments. So in this sense, I think Professor Xi's research set a very successful model of effectively using legal data set to conduct research. And for database research, we will have to collect proper data and clean it up so as to get it to a useful state. So I can imagine Professor Xi and the team members must have spent quite some time and energy to manage data. And next, due to time limits, I would like to make a very short comment on the contribution of these empirical findings. For instance, as for cross-border disputes, some parties are eligible for choosing applicable law to resolve the potential dispute. This is to guarantee the autonomy of the will of parties. So some researchers advocate to enhance the parties' rights to choose applicable law. On the other hand, in practice, as Professor Xi's research findings show, in those cases where litigation parties lawfully entered an agreement on the applicable law, the actual situation where judges apply the law of Hong Kong or Macau accounts for only a small proportion. Judges seems they are inclined to apply a domestic law. So the reasons for these findings, they may vary from case to case. The possible reasons might be that litigation parties, they are not fully aware of the specific laws relating to their own case. And here, legal technique may play as a bridge to perform as an information gap. And also the application of law actually lies in the discretion of the court. Whatever the exact reasons are, I think this research also already shows the significance of empirical method in testing the effect of legislation, and show us the challenges that theoretical inferences are facing. And it also demonstrated the prospect of conducting further research, such as interview with the parties or judges, or doing individual case study. And it seems to me a series of empirical researches on the same topic can corroborate with each other and to supplement each other. This is how the empirical researches works based on my own experience. And okay, this is basically what I'd like to share today, and hope we can have more opportunity to make discussion on this important topic. And thank you for taking your time.
Yeah, thank you, Dr. Ho. And I'd like to thank our three speakers, Professor Si, Professor Tsang, and Dr. Ho. Well, this webinar shows us that the court system is a key pillar to the integration of Hong Kong and Macau with the mainland China in the GBA. And it demonstrates that having good empirical research is very important to inform policy and practice. I hope you have enjoyed this webinar as much as I have, and I've been very well, I've learned a lot from this webinar. Our next webinar will be on approaches to public space in the Greater Bay Area. And our speaker is Professor Hendrik Sieben, Director of the School of Architecture at CUHK. As originally scheduled in July, but to accommodate the speaker and the international discussants, it has been postponed to August 5th, 1 week later, also a Friday. Please look out for our further announcement on this webinar on August 5th. Again, thank you again for joining us, and I'd like to thank Professor Si, Professor Tsang, and Dr. Ho again for your very insightful and informative webinar. Bye-bye.